Just a general disclaimer, by us giving this information that's educational, this does not create an attorney-client relationship. This is for educational purposes only.
So today we're going to start out with the basics of the Corporate Transparency Act. So the CTA, it's a new federal law that went into effect at the beginning of this year on January 1st. It requires certain businesses that are called reporting companies to provide what's called beneficial ownership information, or BOI for short, about the business and the people who own it, who control it, and even who helped create it. So that information has to be provided in a report to the Financial Crimes Enforcement Network. So reporting companies that are subject to the CTA are companies that were formed by filing formation documents with Secretary of State, for example. So reporting companies, generally, they encompass corporations, LLCs, limited partnerships, LLPs. Basically, it's the vast majority of companies. It doesn't include sole proprietorships. As a general rule, most companies are going to constitute reporting companies. A domestic reporting company is a company that was created by the filing of a document with the Secretary of State in one of the states of the United States or under the authority of an Indian tribe, whereas a foreign reporting company is an entity that was formed under the law of a foreign country, but that's registered officially to do business in any state or tribal jurisdiction.
The law is the current law, and just because there is litigation pending doesn't mean that anyone can use that as a basis not to comply. Because medical practices are required to be professional medical corporations filed with the Secretary of State of California, all medical practices would be considered reporting companies, regardless of whether the medical practice is a C corporation or an S corporation. With respect to management services organizations, they're usually set up as LLCs, sometimes as a corporation. So the MSOs are also reporting companies under the CTA. So unless there's an exemption that specifically applies, medical practices must comply with the CTA. There is an exception for large medical practices. So a large medical practice is a practice that employs more than 20 employees on a full-time basis in the United States and has filed in the previous year federal income tax returns with more than $5 million in gross receipts for sales, and then also would have to have a physical office here in the U.S. So the entities that are exempt, that includes publicly traded companies, nonprofits, and as discussed, large operating companies, and also general partnerships. So anything where you're not filing something with the Secretary of State. And we're not just talking about California, Delaware, any other state. So LLCs also have to report. So all of the entities across the board that a physician may have. And so another exception though is if an entity stopped existing prior to January 1st of 2024. So this law is for any entities that were existing in this year, whether or not it was set up this year or prior to this year. And so there is a list of 23 exemptions that do not need to file an initial report. However, if there is a reporting company that filed an initial report but then later becomes exempt, there's a way that you have to report that also. You can't just stop reporting. There is a way that it needs to be reported in FinCEN, reporting that, stating why they are now exempt. So there are 23 exemptions here. So we have banks, venture capital fund advisors, insurance companies, accounting firms, large operating companies, and so forth. FinCEN requires that every beneficial owner and each company applicant who registered or created the entity this year has to report their information. And by information, we are talking about their driver's license, passport, home address, and it has to be uploaded to the federal government in a specific online format. First, what you need to do is identify who the beneficial owners are. And so that is any individual who directly or indirectly has at least 25% ownership interest of that company. And it also includes anyone who may not be an owner, but somebody who exercises substantial control over a reporting company. In terms of the substantial control test, what we're looking at here is that the company needs to think about who are all the individuals who exercise substantial control over the company, even if they don't have 25% interest. It could be a shareholder who has less than 25% but is listed as an officer with the Secretary of State, right? And so there's criteria for what is substantial control here. So for example, a senior officer would be a president, a CFO, a GC, a CEO, a COO. So all of those individuals would need to be reported as well, not just the owners of the company. So if someone is asking you to be an officer of a company where you're not an owner, you should think twice about it, because your information is being reported and anything that the company does will reflect upon the officers as well. This would also be considered an individual or is an important decision maker or has some other form of substantial control over the reporting company. The ownership interest doesn't have to just be, voting stock. I mean, it could be equity, stock, voting rights, profit interest, convertible instruments, stock options, non-binding privileges, any ability to buy or sell, contractual, anything that could be used to show any type of ownership interest. In fact, there are some entities that are set up that have multiple levels of ownership interest. So you don't report the entities, but who are the owners of all of those entities. So where there's a trust that owns 25%, the following people have to report as beneficial owners. You've got the trustee, trust protector, anyone who has control over investment decisions, anyone who has the authority to dispose or distribute trust assets, any beneficiary who is the sole principal recipient of the income and the principal, or a beneficiary who has the right to demand a distribution, to withdraw substantially all of the assets, or it includes a grantor who retains the right to revoke a trust or to withdraw trust assets. So who is not a beneficial owner? A minor child is a common example, or somebody who is an intermediary, a custodian, nominee, or just an agent, or an employee. Employees do not need to be reported. Or if somebody has a future right of inheritance, like a beneficiary in the future, they don't have to be reported. All right, now this is a very interesting new law. The company applicant has to provide their information too. And by information and who the company applicant is, we're talking about the person who is primarily responsible for directing or controlling the filing of setting up that entity. But this is not for any entity set up prior to this year. This is for any entity starting January 1st of this year and going forward. The reporting company information includes the full legal name of the company, any trade names, any DBAs, the current address of the company, and the EIN number. Now, the information for the beneficial owners is very specific. You have to give the full legal name of the person, the date of birth, the current home address, and their ID. You have to take a photograph of their government issued identification, and it has to be valid. It can't be an expired passport. It can't be an expired driver's license. It has to be a current government issued identification, and also their social security number. It's very important to report accurate information. This is under penalty of perjury. If there is a change, it must be reported within 30 days, whether or not it's beneficial ownership information, the company structure, any addresses if somebody moves, or anything like that. All of that has to be reported. It's not from 30 days of when you filed it. It's from 30 days when you find out that there's a change. Now, the reason we're here is because the penalties are really shocking. I personally haven't seen anything like this in 20 years of practicing law. The penalties are up to $591 for each day that the violation continues. That's civil penalties. Criminal penalties, you can be fined up to $10,000, and there's potential criminal imprisonment up to 2 years. Everyone has to comply by the end of this year. And the scope of this applies to what is called a willful failure to report, to update, or correct beneficial ownership information. And the scope, it applies to willfully providing false or fraudulent information or failing to report required information. The understanding is that this will be enforced beginning in January 1st of 2025. So it is very critical that if you know anyone that has a corporate entity, they need to get this done. They can try doing it themselves. If they need help, contact us, contact our CPA, whoever helped them set it up. It's not just the owners that would be held accountable, but it would also include senior officers. They could be held personally accountable. And a lot of times, folks, they'll own a business and they'll have other officers who are listed on the statement of information with the Secretary of State, and those individuals can be held responsible as well. So it's not just owning a business, but if you have a high level level position in a business, you need to make sure that your name is also provided as someone who has substantial control of that business. End of this year is the deadline. So if there is an existing company, an existing medical practice, an existing MSO, an LLC for a physician, if that was created prior to this year, the deadline is in 2 months. And if there is a new entity that is formed this year, January 1st of 2024 through December 31st of 2024, that entity will have 90 days to report the beneficial ownership information plus who created the entity. So if it was prior to this year, you don't have to state which attorney, which CPA, which person helped you create the entity, but if you create the entity this year, not only do you have to provide the driver's license and home address for the owners, but you have to provide it for your attorneys, for your CPA, whoever is creating or setting up that entity for you this year. Any entities after this year have 30 days. So this year it's 90 days, and then starting from next year, it's 30 days where that information must be provided.